Hello, this is a blog about the Deport Now, Appeal Later policy and out-of-country rights of appeal. I've blogged about this at some length because we have a new case on it. It's a big one. It's the UK Supreme Court's decision in Chiari and Blindloss. That case was a judicial review challenge against the decisions by the Secretary of State to certify two persons' claims, human rights claims, under a new power called Section 94B. This section is basically the statutory force behind the government's Deport Now, Appeal Later policy. That policy does what it says on the tin. It allows the Secretary of State to issue a certificate. Sounds harmless enough, but actually it's quite harsh in its effect. Because once that certificate is issued under Section 94B, a person whose human rights claim has been refused can only appeal against that decision if they leave the UK. Just think about that for a moment. If you're, for instance, trying to regularise your status or resist a deportation order against you, and you make a human rights claim saying to the Secretary of State and to the Home Office that, look, I've got a family here, I've got several children who are going to be severely affected by removal of me from the country, and let's say the Home Office turns around and says, nah, we're not persuaded, we reject that claim, we're not even going to really consider or think about the evidence much, we might have a look at the immigration rules, but you fail under them, you have to be removed. And let's say you want to challenge that decision. Well, if the claim is certified under Section 94B, the effect is you cannot appeal against that decision unless you leave the UK. So it's pretty harsh because, as you can imagine, people whose claims are based actually on their existing family life and the strengthening family life that they have in the UK have to abandon their family units and move to another country in order to challenge the decision that's based on the quality of their life with their family unit. So it set up a situation which, from a number of angles, quite a lot of us were concerned in terms of its fairness. A lot of us were also concerned about the fact that these certificates were being issued in cases where they probably shouldn't have been. In cases where, for instance, the family life is relatively good quality, in which there's good evidence, detailed evidence about the interests of children who are being affected, or, for instance, the length of time that someone has spent in the UK and their efforts to do good if they have previously committed crimes and their remorse as to any offences they've committed. And so there was a concern, really, that this power was being abused. Not only was it overly harsh in its effect, but it was being applied in arguably irrational ways from time to time. There were also issues around the very idea of out-of-country appeals. This whole notion that an immigration judge sitting in the tribunal can fairly and fully assess a claim based on family life if the appeal is being brought by a person who's based in Iran or based in Syria or anywhere else. It seems to raise a number of questions, serious questions, about the quality of the facilities in the tribunal to actually enable those out-of-country appeals to happen and to happen fairly and effectively. And so this issue really came to the fore in Chiari and Blindloss, this Supreme Court case that we're all a bit excited about. Now, the key findings, which I just want to pluck out in this video, and I go into a lot more detail in my blog accompanying this video. The key finding is that the Supreme Court, Lord Wilson giving the main judgment, concluded that where someone is appealing against a deportation order on the basis of their Article 8 right to family and private life, then in most cases, live evidence is needed. You need the person there actually able to be seen by the tribunal, either in person or via an effective video link. But the difficulty with video link is that, as many of us who use the tribunal know all too well, the facilities are pretty basic. It can be hard at times to even get an usher for the courtroom that you're in, to find the judge or to assist with various practicalities, because the actual court staff, the court and tribunal staff, are spread so thin. Many of them cover several courts. Imagine the complexity if you're then introducing another layer of video link technology into the mix. You've not only got to set up the video link in situ at the tribunal with all of the potential pitfalls that might come with, but there's also got to be a video link at the other end in the distant country that's actually working, that can connect. There's sometimes a bridging service that's needed to connect one live link to another live link in another part of the world. It's a minefield. I mean, it's hard enough to even have a Skype call without some form of connection dropping or quality issues. How then can you expect an immigration judge to make an informed decision on such low quality evidence? And this was really a key preoccupation of the Supreme Court based on the evidence. The ultimate conclusion then was that because of the failure of both the Secretary of State but also the Ministry of Justice to actually provide adequate facilities for out-of-country appeals against deportation orders to be heard, therefore the current system simply does not comply with the European Convention on Human Rights, and in particular the procedural requirement that's built into Article 8.2 of the Convention. That's the right to a protected right to family and private life, and this idea that it's not enough just to have protection of that right in the abstract. Where that right is reinforced and defended through judicial proceedings, those proceedings have to be adequate. They have to give an effective remedy and an effective right of appeal. Standing back from the detail, ultimately, when someone is given a right of appeal against an immigration decision, whether that be against a deportation order or decision, or an immigration-based refusal, whether that's a refusal of leave to remain or a refusal of entry to the UK, that right of appeal has to be effective. It's not enough to just give someone a token right if they can't actually exercise it and participate in the proceedings on an equal footing with the Secretary of State. Another bizarre side of this whole story is the fact that at its core, these certificates, the Deport Now, Appeal Later certificates under Section 94B, are on one reading fundamentally flawed, because what they allow is for the decision maker, the person who actually issues this certificate, to effectively weaken and obstruct the ability of the person who's appealing to bring their appeal effectively. So not only are you faced with this certificate, but this certificate weakens your appeal. Further, the person who's sat on the other side of the appellant and the appellant's representatives is the Secretary of State. So the same person who weakens the merits of the appeal and obstructs the access to the tribunal of the deportee, the person who's bringing the appeal, is the same person who's actually opposing the deportee's appeal. So there's fundamentally a sort of unfairness and a repugnancy about this whole situation, which the Supreme Court did pick up on. This is a hugely embarrassing judgment for the Secretary of State and for the Ministry of Justice, but it's one that strengthens the rule of law and strengthens this principle that people, whoever they are, who are affected by immigration decisions, and more broadly, who have statutory appeal rights, need to be able to exercise them effectively and need a kind of fair access to the tribunal system. So it's good news for once in a while. Credit should go, I think, to the claimants who brought these appeals and also their legal representatives, who provided the Supreme Court with compelling evidence of the sorts of unfairness that their clients would suffer in trying to actually appeal against deportation, which is a hard task even when it's done in person, made even harder when it's done from overseas. Credit also goes, I think, special credit to bail for immigration detainees who actually intervened in this Supreme Court case, were represented, and again provided high quality evidence of the sort of practical hurdles facing appellants who are trying to exercise an out-of-country right of appeal against a deportation decision. Those hurdles included things like basic practicalities, time zone differences, having to hire out conference venues in a foreign country at great cost for up to 11 hours, having to shell out from their own pockets, and bearing in mind there's no legal aid in most cases of appeals against deportation based on Article 8. The costs were prohibitive, the technology had to be installed at both ends and also hired out and paid for the facilities used in the UK as well. Not only that, you've got to pay somebody who knows how to operate the technology, and we all know that lawyers aren't always necessarily up to scratch on operating video link technology, not least the type of technology that is used in certain courts in the tribunal system. So it's just a practical, logistical, financial nightmare. But it's a nightmare that's been imposed upon quite a number of people so far. The Supreme Court heard evidence that of the 72 appeals that had been brought out of country following removal of a person who had a Section 94B certificate made against them, of all those appeals, none had succeeded. Again, it suggests that actually there is no success rate. You can forget success rate when you're talking about bringing an out-of-country appeal in such a complex, fact-sensitive area. I've been asked to respond by one of my Twitter followers, Onuhua Olere, who has asked me, please Ben, what happens to those already deported under this Section 94B Act? That's a really good question from Onuhua, and the answer will obviously depend on the specific facts of each case, but it's of great concern that people have been removed under this power, that they've perhaps even had their appeals heard, their appeals have been rejected, and yet, taking a step back, the Supreme Court has now confirmed that in most cases, this power is a disproportionate breach of that person's human rights. So there ought to be some remedy. What are they? What are the available remedies? Well, there's likely to be an array of different options depending on the circumstances. The Home Office does operate a compensation procedure for unlawful decision making, but don't hold your breath if you're applying under that provision, because it's not known for its promptness, efficiency, and for effectively resolving matters. A person might also need to set aside any tribunal determination that's been made refusing their appeal if it's been refused as part of this out-of-country deport now, appeal later system. But not only that, what about trying to come back into the UK? Well, it seems likely that other than sending representations to the Home Office, seeking to invite them to reverse the effects of their decision to remove them pending appeal, if that doesn't draw any success, then the person may well have to make a fresh application for leave to enter with the fees that are associated with that. But all this seems to be rather unfair, because ultimately it's the Home Office that should be remedying and putting right this wrong. If you've been affected by a Section 94B certificate, the generic advice that I would suggest is that you need to seek legal advice swiftly. You need to be put in touch with a good immigration lawyer who can advise you on the public law and immigration remedies that might be available. But I suspect that, sadly, and this is highly regrettable, The majority of people who've been affected by these certificates won't be very easy to trace. We don't necessarily know who they are or where they are, and it might well be difficult to have them access a remedy to put right what's happened to them in a reasonable time frame. The other issue is, giving and taking instructions from afar can be difficult in cases like this, especially where someone's experiencing financial hardship, where they're trying to readjust to their return to their country of origin. Sadly, it appears that the injustices which have happened are perhaps unlikely to be put right in full and in a reasonable time. But spread the word. If you know someone who's been affected by a Section 94B certificate, the Deport Now, Appeal Later policy, put them in touch with a decent immigration lawyer. Now, I've gone into much greater depth on this decision and the implications of it in my blog post. I also talk a bit in the blog post about, and this is a point more for the lawyers of you, there are some suggestions by the Supreme Court that a fundamental shift in judicial review practice may well be called for when challenging decisions to grant an out-of-country right of appeal. In a nutshell, what the Supreme Court, Lord Wilson, has said is that you can rely on evidence. It may be appropriate from time to time for a judicial review application to involve not only evidence but oral evidence, going to the points of the proportionality of the decision, whether or not the decision breaches a person's Article 8 rights to family life. And again, I talk about that more in the decision. It's highly significant, I think, not only for persons on the receiving end of Section 94B certificates, but for others who have been granted out-of-country rights of appeal in their human rights claims. And what springs to mind in particular are those claims based on appeals against decisions to do with deception. So where someone's been accused of cheating in their English language tests, as thousands of students and ex-students have been accused of by the Home Office, some of those people, if those decisions have been taken after a certain point in time, only have a right of appeal that they can exercise from overseas. But again, we come back to this dilemma of how do you effectively challenge a decision that's about whether or not you've cheated and the quality of your English language skills if you're not in the country, and if you're reliant on Skyping in and the connection's bad and you can't necessarily give and take instructions to your legal team during that appeal process itself. In my view, it's highly questionable, and in fact in the upper tribunal's view recently, it has questioned and doubted whether the tribunal is set up to handle these appeals. So again, it's clear that the battle on those cases may well be entering a new and important phase, and that has a wider relevance to judicial review practice. Thanks for listening, and I hope to provide further videos in the same vein on the key cases developing in the UK's immigration law. If you like this video, please let me know. If you find it useful or not, just let me know your thoughts and views in the comment section, and please do read the blog, which goes into much greater detail. Thanks again. This has been Ben Emmanuel from 36 Bedford Row, immigration barrister on Law Mostly. Thank you.